Right, Charmaine, the participant number, oh, it's still going up. I'm just going to give everybody another minute or two before we start the webinar. I can see that we still have some people joining, so bear with me for 1 minute. Let's see if that number stays still. I think it has, and we are now 2 minutes past 5, so I will start. Good evening, everybody, and welcome, and thank you for coming to our webinar looking at how the landscape looks for rent arrears possession claims in a post-COVID world. We'll be looking at what is left, if anything, of the COVID measures that were in place from the beginning of the first lockdown, and what has gone back to business as usual. My name is Niamh O'Brien. I'm a barrister at 42 Bedford Road, specialising in housing and property law. And Charmaine Clubb is one of our new tenants, specialising in civil law and in particular in landlord and tenant. Just a quick outline of the webinar today. Charmaine will be dealing with the first two of those bullet points. She'll be talking to you about where we are now in relation to notices. She'll also be speaking to you about what arrears can now be relied upon in new cases and existing cases for possession based on rent arrears. I will be speaking to you about the debt respite regulations, which came into force in May of this year. Strictly speaking, they're not related to COVID as such. It just so happened that they came into force around about the time that other measures that were put in place to prevent possession being obtained were coming to an end. We will then deal with some issues that can and frequently do arise particularly on the first hearing day of a possession action. And at the end, if we have time, Charmaine and I will deal with any questions that have been brought up in the course of this seminar. You can submit questions as we go along using the Q&A button either at the top or the bottom of your screens. We will probably leave it to the end of the seminar before we respond to them. Well, I certainly will, because I'm not that good at multitasking. But we aim to have this finished up, including the Q&A, no later by 6 o'clock, if not certainly before. So at this point now, I am going to hand over to Charmaine, who's going to start off speaking to you about notices.
Thank you, Niamh, and good afternoon, everybody, and thank you very much for joining this webinar. I'm going to kick off by talking to you about Section 8 notices and the types of rent arrears that can be relied upon for possession claims. So diving right into notices, first things first, England or Wales? I think it's important to say at the outset that this is a webinar about English law. Wales has a totally separate regime. So if you have a Welsh case currently on your desk, then please listen to what I'm about to say at your peril. So looking at that second bullet point there, Section 8 notices, the prescribed form. As I'm sure many of you will be aware, as of the 1st of June of this year, a new prescribed form of Section 8 notice was introduced. The new form largely mirrors the old form, but it also reflects the up-to-date procedure for obtaining possession. I'm not going to show you the new form now, as in 3 days' time, an even newer and shinier form will be introduced. But for those of you who don't already have a copy of the current form, it can be found quite easily online, for example, on Practical Law. So turning to the third bullet point, modified notice periods during COVID. So to protect tenants from eviction during the pandemic, the notice periods before possession proceedings can be commenced have been extended numerous times by the government, and there have been various iterations of regulations bringing in these changes. So I've put the modified notice periods up on the slide. As we can see, those are 26th of March to 28th of August from last year, 29th of August last year to 31st of May this year, 1st of June this year to 30th of September, and then from 1st of October onwards. So if we just flick over to the next slide, in terms of where we are at the moment, we are currently coming to the end of the third modified notice period, so 1st of June to 30th of September, and the incredibly wordy applicable regulations are up on the slide for those of you who are interested. But in essence, those regulations mean that the majority of rent arrears possession claims have a reduced notice period. So rather than being 6 months notice period, that is now 4 months. However, if an exception applies, then the notice period may be even shorter than that. So for example, where there is at least 4 months rent arrears that remain outstanding, and the landlord is relying on one or more of grounds 8, 10 or 11 of Schedule 2 to the Housing Act 1988, then the notice period is 4 weeks rather than 4 months. So that's considerably shorter. The regulations on the slide also extend the relevant period in Schedule 29 to the Coronavirus Act 2020 until the 30th of September of this year. So in other words, the current rules remain in force until the end of the month. So just flicking over to the next slide, what happens after the 1st of October? So in terms of where we're heading, in a mere 3 days' time, the regulations that are up on this slide will come into force. And the effect of those regulations will be to revert notice periods to their pre-pandemic levels. So for grounds 8, 10 and 11 of Schedule 2 to the Housing Act 1988, the notice period will be 2 weeks. And for ground 1 of Schedule 2 to the Housing Act 1985, the notice period will be 4 weeks. So the headline is, if you're seeking possession for rent arrears, then you are far better off waiting until after the 1st of October to serve your Section 8 notice, as the notice periods thereafter will be considerably shorter than they are at the moment. And as I've already mentioned, a new prescribed form of notice under Section 8 will also be introduced for any notices served on or after the 1st of October. In terms of the relevant period, that will also be extended again until the 25th of March 2022. So this means that the government retains its emergency powers to impose longer notice periods until this time. And although it's not terribly likely, I think everyone should be alive to the possibility that the government could change its mind at the last minute, as it has been known to do throughout the pandemic. And the government could decide to reintroduce longer notice periods again. So just flicking over to the next slide. So at this point, you might be wondering how you go about keeping track of the various modified notice periods in relation to each ground of rent arrears possession. So I think you'll be pleased to know that there is technical guidance on the government website that has done all the hard work for you in the form of this rather hideously dense table that I've reproduced for you on the slide. As this is a webinar about rent arrears possession, I've culled all of the grounds that relate to other reasons for eviction. So we just have here grounds 8, 10 and 11 under the 1988 Act. So in other words, the rent arrears grounds that apply to assured and assured short hold tenancies. So I won't read through the whole table now, but if we just look at the top row by way of example, we can see that if a landlord is relying on ground 8, so that's serious rent arrears at the time of service of the notice and possession proceedings, then the pre-pandemic notice period was 2 weeks, which then changed to 3 months at the start of the pandemic. which then changed again to either 4 weeks or 6 months, depending on the level of arrears, which brings us finally to the current modified notice period of 4 weeks where the arrears are at least 4 months, 4 months where the arrears are less than 4 months, and from the 1st of August onwards, 2 months where the arrears are less than 4 months. So I'll just give everyone perhaps just a moment or two to have a quick glance through the rest of the table, or to take a screenshot as you may wish. But equally, the full technical guidance can easily be found through a quick Google search. So I wouldn't worry too much about processing everything that's on this slide.
Oh, right, hang on.
Thanks, Niamh. Okay, so, and again, I've just put up the technical guidance in relation to the 1985 Act. So this is the ground for rent arrears relating to secure tenancies. And again, it's pretty self-explanatory, but I think it's just useful for people to know that this technical guidance is available, and it sets out all the information really clearly in this nice tabular form. Okay, so if we move on to types of arrears. So just looking at those first 2 bullet points, what if the arrears arose after March 2020? And what if some of the arrears arose after March 2020? So the long and short of it is that there is no technical defence per se to a possession claim simply because arrears arose during the pandemic. So in that sense, the second bullet point is a little bit of a trick question. And unless the debt relief scheme applies, which Niamh will be speaking to you about shortly, then normal rules operate irrespective of whether all or some of the rent arrears arose during the pandemic. But having said that, the fact that arrears may be COVID related may be relevant to the extent that the question of reasonableness is being considered under any of the discretionary grounds. So, for example, if you have a tenant who has struggled financially due to COVID and he puts forward a sensible arrears repayment plan, then that may win the sympathy of a judge under a discretionary ground. And in those circumstances, a landlord may struggle to persuade the court to get an outright possession order, or alternatively, they may get a suspended possession order. In terms of the key dates for the accrual of rent arrears, the relevant dates will differ depending on which grounds you're relying upon. So, for instance, for ground 8 to bite, the level of arrears must exceed the relevant limits both at the date of service of the notice and at the date of the possession hearing. So just as an example, let's assume that rent is due on a monthly basis. Then for ground 8 to be engaged, 2 months of rent arrears need to have accrued both at the date of service of the notice and the date of the possession hearing. So if your tenant turns up at the hearing having cleared most of their arrears, perhaps with only 1 month's arrears outstanding, say, then the landlord can no longer rely on ground 8, and it may be that they need to fall back on discretionary grounds in those circumstances. So just looking at that last bullet point there, does it matter whether or not the landlord is local authority? As you may have guessed, it does matter whether or not the landlord is local authority. And essentially for local authorities, there is no mandatory ground 8 equivalent for rent arrears possession. So in addition to establishing the relevant arrears, a local authority must also show that it is reasonable to evict the tenant. So there's that additional hurdle that local authorities need to think about. So that's all from me for the time being. So I'll hand the baton back to Niamh. Thanks.
Thank you, Charmaine. Just moving on to my part, just dealing with the, or to give them their full name, the Debt Respite Scheme brackets, Breathing Space Moratorium and Mental Health Crisis Moratorium brackets, England and Wales Regulations 2020. They have been colloquially started to be known as the breathing space regs and the mental health crisis regs, or the moratorium regs. They came into force on the 4th of May 2021. As I said at the outset, they're not strictly related to COVID at all, and they've been bubbling away in the background for at least 3 years. And they have been sort of a child really more of the law relating to insolvency rather than to landlord and tenant. But they will, I think, possibly become very, very relevant to people acting for landlords and for tenants in cases involving rent arrears in the future. As I said, they came into force around about the time that the COVID restrictions were drawing to a close toward the middle of this year. The regulations can prevent all creditors, including landlords, from taking action to enforce payment of any affected debt. They can be extend to all steps in the possession process. That includes serving notices and starting proceedings. It also covers enforcing orders, but it doesn't act as an automatic stay on existing proceedings, and that is an important point to note. There's a new practice direction 70A, which is pretty short, and it just gives some general procedural issues guidance to creditors when they're being served with a notice under the regulations. It remains to be seen really how much of an impact these regulations are going to have on day-to-day practice. Are they going to be a game changer like the Human Rights Act offences and other public law defences, Equality Act offences? Are they going to be, like so many other statutory interventions into landlord and tenant relationships, a bit of a damp squib, like introductory or starter tenancies or demoted tenancies? Watch this space. My feeling is that they are going to become more and more commonly encountered in the county courts as tenants become more aware of them, and as they become more publicised generally. So dealing first of all with the what the government guidance refers to as the standard breathing space. I've misspelled it, breathing space. My apologies for that. That's to differentiate it from a mental health crisis breathing space, which I'll come into in a minute. The first point to be made about both of these moratoriums is that they can only be put in place by a registered debt advisor authorised by the Financial Conduct Authority. There are lots of registered debt advisors around. Some of them are in private practice, some of them you will find in citizens advice, or citizen advice bureaus will certainly know how to signpost somebody who comes to them looking for help to one of these persons. If the moratorium is put in place, it will cover all qualifying debts. This will include rent arrears. A standard breathing space lasts for 60 days, and it can only be applied for once in a 12-month period. And the important point to note about the standard breathing space moratorium is that ongoing liabilities are not affected by the order. That means in theory that you can start chasing for debts as they accrue after the breathing space starts. You can't chase debts which have accrued before the breathing space moratorium starts. The reality is, though, however, because it's the standard breathing space moratorium is relatively short, I suspect that most people will simply wait until it's come to an end before they start chasing debts or starting possession proceedings or any proceedings for debts which have accrued after the moratorium starts. The procedure for obtaining a breathing space debt is set out in the regulations. It's, as I said, it's something that has to be put in place by a registered debt advisor. It's not something that anybody can just do by themselves. If the debt advisor is satisfied that it is appropriate for the debtor to enter into a moratorium, they will register the moratorium with the insolvency service, and it is the insolvency service that will notify the landlord or any affected creditor of the fact that the breathing space moratorium has started. Once notified by the insolvency service, all enforcement action must stop. That includes writing letters, starting proceedings, serving notices, and putting any pressure whatsoever on the debtor to pay the debts. The other duty that falls onto the affected creditors as soon as they get this notification from the insolvency service is that they must inform the court the fact that the moratorium has started. Additionally, the creditor has got to conduct a search for additional debt, which could be included in the moratorium, but at the moment isn't, and they must notify the debt advisor of this existing debt, and the debt advisor will decide whether or not it will be included in the debts covered by the moratorium. The mental health crisis moratorium is two significant differences. The first is that it's open-ended. The mental health crisis moratorium will last for as long as the person is receiving treatment for their mental health crisis, and 30 days beyond that. So it could be a significant problem to a landlord to find that a tenant has entered into a mental health crisis moratorium, because they will have no control over the extent to which they will have to wait before they can start enforcement proceedings against that person. So, sorry, I'm just bringing this up. So in terms of the procedure, the debtor themselves can apply to a registered debt advisor or a debt advisor professional. The two terms are interchangeable. Alternatively, and again, this is the difference between a standard moratorium and the mental health crisis moratorium, someone can apply on the debtor's behalf, and that application really can be made by anybody who's puts themselves forward as acting on the debtor's best interests. The debtor and the debt must meet the eligibility criteria for a standard breathing space. These are set out in the regulations, but they're not surprising. There are things like resident in England and Wales, in debt, not able to pay. So there's no, the eligibility criteria are relatively wide for a standard breathing space moratorium. The other significant difference is that the ongoing treatment must be certified by what's called an approved mental health professional. Now, this is a specific category of mental health professional people. It's not just somebody, it's not GP, it's people who are usually registered with the local authority social services as an approved mental health professional. It's not just anybody who is engaged in a mental health provision. These are the additional eligibility criteria for a mental health crisis moratorium. Firstly, it's somebody who's actually detained or colloquially sectioned under the Mental Health Act. Alternatively, somebody who has been removed to a place of safety under the Mental Health Act. Somebody who is getting crisis care, either as an inpatient in hospital or in the community from a specialist mental health team. Just pausing there for a second, if that isn't happening, the debtor isn't eligible. It's not enough for the debtor, for example, to go along to their GP and say, I'm having a crisis, will you please certify me as being eligible for a moratorium? They have to be somebody who's having this specialist mental health care in the community or as an inpatient. The the registered debt advisor must have the evidence of mental health crisis care before they enter the debtor into a moratorium. If they don't have that, then they're not supposed to register the moratorium has started. The application process is dealt with by the Money and Pension Service, and they provide a single point of application for the registered debt advisor, effectively to put their recommendation and the evidence they have in support. Just pausing there for a second, you won't necessarily, as a creditor, be entitled to see the evidence of the mental health crisis care that was used to support the application. You may, at a later point, if you wish to challenge the making of the moratorium, but it's not something that you're going to see necessarily when you're notified that the moratorium has started. The effect of the mental health crisis breathing spaces is, again, it's similar to the effect of the standard breathing space. All enforcement action must stop. No enforcement act may be taken in respect of debts accruing after the mental health breathing space commences. Unlike the standard breathing space, the mental health crisis breathing space is open-ended and will remain in place for as long as the specialist mental health treatment lasts, as confirmed by the approved mental health professional, plus an additional 30 days at the end. And ongoing liabilities are covered. So while the breathing space will not remove the obligation on the debtor to pay the debt, it will stop any enforcement action in relation to debts which have accrued after the moratorium has started. It is possible to challenge the decision of a registered debt advisor or debt advice professional, whichever one you, again, they are interchangeable. The regulations provide for a half-time review of a standard breathing space moratorium by the registered debt advisor. So that should take place somewhere between the 25-day mark and the 35-day mark. I doubt in most cases that's going to be anything more than a box-ticking exercise on behalf of most debt advisors. Creditors can request a review of the moratorium by the registered debt advisor. The creditors can apply to the court to cancel a breathing space moratorium or a mental health crisis moratorium. The creditor can additionally seek permission of the court to take enforcement action, but permission will only be granted if it does not undermine the purpose of the moratorium. I can't imagine the circumstances in which permission would be granted, because it seems to me that if you're taking away the moratorium, it does by definition undermine the purpose of the moratorium, unless the debtor has come into some kind of a windfall that everybody knows about, which is unlikely to happen in most cases. The grounds upon which a creditor can seek either a review or a cancellation are set out within the regulations. The creditor can argue that the moratorium has caused it unfair prejudice to it in particular. As for the answer to that is, in most cases, the fact that it's going to obviously prejudice the interests of any creditor to be unable to take enforcement action. I suppose it could be argued on the part of the landlord that they're not just in some cases seeking to enforce a debt, but they're also seeking to enforce a right to possession. So it's not like Thames Water wanting to chase for a bill or a credit card company wanting to chase for a bill. It could be argued that a landlord is seeking the return of its right to possession of something that it owns. but again, it's early days. There's no reported case yet of a landlord making an application for a cancellation to court. The other grounds are more technical grounds which would be available. The debt didn't meet the eligibility criteria when the standard breathing space or the mental health crisis breathing space was applied for. The debt is not a qualifying debt. That is unlikely to be relevant in on the question of rent arrears. The debtor has sufficient funds to discharge their debt. Is also a ground for either review or for cancellation of moratorium. There are time limits in relation to both the request for a review and the request for a application to the court. The time limit for the request for review is 20 days after the moratorium starts. You've got 50 days time limit to make an application to the court. And that's from the date of the request for the review. So that much like a homelessness application, you've got a right to review, and if you're not happy with that, you've got a right to go to the court. And if you don't get a response from the reviewer, then you can just go to court if they haven't met within the 50-day time limit. The time limits appear to be strict, so I would keep an eye on the timings on those, because it seems to me that if you miss the boat on making those applications, it's unlikely the court's going to be able to help you. If you are served with a notice of either the moratoria, don't ignore it. The regulations provide that any notice, including a notice of possession, that is served during the moratorium period will be invalid. If proceedings are started during the moratorium period, they're liable to be struck out, and the creditor will be liable for any additional cost caused to others by breaching the moratorium. They will also be liable for any cost caused to any other person if, for example, they fail to notify the debt relief advisor or the registered debt advisor of any additional debts that they are aware of. So that's that. That's a sort of whistle-stop tour of the regulations. There is only one reported case that has in relation to these and how they affect the creditor-debtor relationship. It wasn't a landlord and tenant case, but it was a case involving application, a cross-application for possession. And one point that I will draw to your attention, and it was the case of Axnoller Events Limited and Break. The reference is there, and can I add that you can get copies of these slides from our website. They will be put up there in due course. I will draw that case to your attention, however, because one of the issues that came up in that case is if a creditor wants to challenge a moratorium, do they make an application in the existing proceedings, or do they have to make a standalone Part 7 or Part 8 application? And the court in that case concluded that it would be better to make a standalone application rather to start new proceedings, because the challenge themselves are not part of the proceedings. The point that that was made in that case was that if they are standalone proceedings, there will be all of the usual procedural steps will be taken. That will include disclosure, and that will mean that on disclosure, the certification from the approved mental health practitioner is something which in theory could be disclosed, which means that it will be easier for the creditor to see if there are grounds for challenge, if perhaps they're not satisfied that the person who has entered into the mental health crisis moratorium, if there is suspicion that they're abusing the procedure, it may well be that starting standalone proceedings would be preferable, because there will be disclosure and you will get to see the certification from the approved mental health practitioner. So that's where we are. As I said, it remains to be seen to what extent they are going to impact on possession proceedings for rent arrears. That's a bit of an unknown, but I would say that they have the capacity to have a very significant impact on rent arrears, possession claims going forward. So now that takes us to our troubleshooting part of the seminar, and so these are some of the these are some issues that Charmaine and I have discussed as to things that can on a standard basis come up, particularly at a first hearing of a rent arrears possession claim. So what we're going to do is Charmaine's going to unmute, and we're going to deal with it point by point. So Charmaine, what do you do if you turn up to court and you discover that your Section 8 notice is defective in some way?
Yes, so I think this is a common problem that can arise. And I think sort of the first thing to say is the various ways in which the Section 8 notice could be defective. So, for example, the notice could fail to state the grounds relied upon, or the level of rent arrears, or it could assert the wrong date after which possession proceedings can begin. I think if any defects go unnoticed until the day of the hearing itself, then one option is to make an oral application to effectively dispense with the Section 8 notice. But it is important to remember that if you take that course, then you'll no longer be able to rely on a mandatory ground for possession. So that's something to be aware of. I think alternatively, if you are aware of the defects before the day of the hearing, then obviously the safest course is to just cure those defects by serving an amended Section 8 notice on the tenant, which supersedes the defective notice, sorry. Another thing is the court may simply exercise its discretion to adjourn the first possession hearing. I actually did a possession case last week, which had been adjourned from June, so that defects in the claim form and Section 8 notice could be remedied and the relevant documents reserved on the tenant. So that situation, I think, can inevitably be quite frustrating for a landlord who wants to get possession quickly. There is one case I also want to bring to everybody's attention, and that's the case of Pease and Carter, 2020 EWCA Civ 175. And that might be worth looking at, where the error relates to the date after which possession proceedings can begin. So effectively, the Court of Appeal found that a landlord's Section 8 notice was valid, notwithstanding a typographical error in relation to the date after which proceedings could begin. And the Court of Appeal held that the reasonable recipient would have understood the notice as giving the tenant at least 2 weeks warning of the commencement of proceedings, and the cover letter provided to the tenant, which had the correct notice period, could be taken into account in determining what the reasonable recipient would have understood the notice period to be. So I just thought I'd bring that to everybody's attention, and certainly that case is helpful for landlords who find themselves in that particular predicament. But obviously it is preferable to check Section 8 notices carefully to ensure that they are watertight before being served. But Niamh, I don't know if there's anything else you wanted to add to that.
Just coming back to the reasonable recipient test, that comes from the well-known case of Manai Investment Company Limited and Eagle Star Insurance. And I would just say to anybody representing a landlord, if there's ever any problem with a notice, just say Manai Investments Company Limited, because the district judge will know what you mean. And it basically means don't take silly technical points if the meaning of the notice is obvious. It is the last refuge of the landlord who has belatedly discovered that they've got a technical problem with a notice. Okay, so right, next problem. So you turn up to court and your Section 8 notice is fine, no problem with your pleadings, but the tenant at that point denies receipt of the Section 8 notice. Charmaine, what do you do about that?
So I think the first thing to do in this situation is check the tenancy agreement to see if there is a deeming provision. So in other words, you're looking to see if Section 196 of the Law of Property Act 1925 has been incorporated into the agreement. And in the majority of tenancy agreements, such a provision will have been incorporated. But essentially what this means is a notice is deemed served if it has been left at the property or sent to the tenant by recorded delivery. So that can be a nice saving grace if your tenant denies having received the Section 8 notice. If, having checked the tenancy agreement, you discover that that provision has not been incorporated, then it will be incumbent upon the landlord to show that the tenant did receive the Section 8 notice. One of my colleagues in Chambers actually had a full day mini trial arguing this discrete issue. So treat that as a cautionary tale to not wind up in that situation and ensure that the service of the notice can be proven. But I would suggest that if there is no deeming provision, then a landlord would be wise to effect service personally and to file an accompanying witness statement and a certificate of service with the court, just so there's no room for doubt that the tenant received the notice. Niamh, I don't know if you wanted to chip in.
Just one further thing. This is particularly relevant to older tenancies where you might not have to hand the tenancy conditions that were in force at the time. Don't necessarily assume that you will be able to rely on deeming provisions in later versions of your terms and conditions unless you've got evidence of incorporation. That's a whole other can of worms sometimes, but long story short, evidence of service, even if it's just a certificate of service or something in a witness statement to say it was served, will help, because if you can bring some evidence to court to say, well, it went through the letterbox, then even if you've got problems with either you can't find the deeming provision or you maybe struggle to show the deeming provision has been incorporated into an earlier tenancy, it will be easier to persuade a court that it is more likely than not, if the letter went through into the letterbox, that it came to the tenant's attention. Yeah, probably not the first hearing. Right, okay, problem number 3, housing officer does not attend the hearing. Charmaine.
So I think ultimately, even if your housing officer doesn't attend, you can still rely on the written evidence and the pleadings to evidence the rent arrears. I mean, certainly in my experience, often the judge has not even acknowledged that my housing officer is there, let alone ask them to confirm the truth of their witness statement or give evidence, certainly at that first hearing anyway. So I think ultimately it shouldn't be too much of an issue if your housing officer doesn't attend, but I don't know what you think about this, Niamh.
9 times out of 10, I think you're quite right that the court, particularly if matters aren't being contested, the court isn't particularly interested. If things are being contested, it might be a bit different. But even if things aren't contested and you don't have a housing officer along to confirm the witness statement, you can always rely on the contents of the witness statement at the first hearing, because the first hearing isn't a trial. So you can rely on the written evidence without calling it orally. If there's any important part of your case which is not dealt with in the witness statement, but is dealt with in your pleadings, then you can always rely on your pleadings, because again, it's not a trial, and the pleadings, because they have a statement of truth, can, in a non-trial hearing, be relied upon as evidence of what they say. So your particulars of claim will set out the fact that the landlord owns the property, the tenancy started on this date, the tenancy agreement was this kind of tenancy agreement, notice was served on this date. So if that's all in pleadings with a statement of truth, you can rely on that as evidence, even if you don't have a housing officer coming along and their written evidence doesn't deal with it. Okay, so what do you do if you are not supplied with an up-to-date rent statement on the first hearing? Charmaine, is this a problem?
So I think probably the easiest thing to do if the housing officer has attended is simply to get them to phone their office and get the figures for the current level of rent arrears and the last 3 payments on the account. So then at least council will have those numbers at their fingertips ready to give to the judge. But ultimately, I think if there's no up-to-date rent statement and no housing officer, then you may be in some difficulty because you will need to show what the rent arrears are. But Niamh, I don't know if you've got any suggestions about this scenario.
Yeah, well, what I tend to do in this case is to get if you haven't got somebody with you who can give evidence, then you're in difficulty. The obvious thing to do is to get whoever you have with you from the landlord to call in and find out from someone what the up-to-date figure is, and then have them give oral evidence in court as to what the figure is and how they got it. Particularly if it's being contested. It will be particularly important for cases on ground 8, where you're either relying on a housing officer or maybe a managing agent from a private landlord. You need to have the evidence of the state of the arrears on the day of the hearing, because if you don't have that, you might not be able to rely on ground 8, which requires the court to be satisfied as to the position both at the date of service of the notice and at the date of the trial. Right, final problem. What do you do if you don't have a statement of costs?
So I think in a way it's a bit of a trick question, as many rent arrears possession claims will fall within the fixed cost regime in any event. So you wouldn't necessarily need a statement of costs in that scenario. And just as a refresher, I'm sure many of you will already know, but the fixed cost regime applies where one of the grounds for possession is rent arrears and the claim is undefended. And CPR 45.12 explains what that means. And under the fixed cost regime, cost recovery is limited to the court fee, fixed commencement costs, and a fixed sum on entry of judgment. I won't give all the exact figures for those things now, but they are quite arbitrary and seem to bear very little resemblance to the actual costs incurred. But essentially, you're looking at about £500 under the fixed cost regime. But where that does not apply, so for example, because there's a contractual right to costs, then a statement of costs will be needed. And of course, if at the first possession hearing, directions are set down for trial, then you'll need, a statement of costs for future. But in that situation, I think ultimately you will be in difficulty without the statement of costs. It may be that the judge will allow the brief fee and take that figure on trust from you, but otherwise I think you will be a little bit hamstrung if you don't have that statement. What I would say is, I think if you're faced with the choice of filing a statement of costs late and not filing one at all, I think it's always better to file one late, because at least then you've got something to show, although the judge may take the view that costs should be discounted to reflect the late filing of the statement. But Niamh, I don't know if there's anything you wanted to say about this one.
Simply that the reality is, if you're dealing with a rent arrears case, the prospects of you recovering costs are going to be remote in any event. So if you haven't got a schedule of costs, I tend to just ask for fixed costs, even if you have either you were never in the fixed cost regime or you've fallen out of it. And if you say to the judge, can we have fixed costs, you'll always get it. But it is in many cases it's going to be academic anyway, because if you're dealing with somebody who can't pay the rent, they're unlikely to be in a position to pay the costs either. Right, okay, so that brings us to the Q&A session. So let's see what lovely things we've got here. So I think the first one, Charmaine, is for you. Are the parties to proceedings required to attend a CMC and go through directions in an undefended possession claim on rent arrears for commercial premises? If the answer is yes, provide the relevant section of the CPO that supports this.
This might be my own idiocy, but I'm not sure I quite understand the question. But I don't know, Niamh, if you have any thoughts.
I can tell you this, I know of no section of the CPR which deals with this, so I think you might be in the hands of the court there, but if it's undefended, I don't really understand how it's going to go much further beyond the first hearing, but I hesitate to stumble into that, because I must confess I don't know the answer. Okay, Charmaine, the next question I think is for you. It's to do with the rent arrears and COVID.
Yeah, so the question is, after 1st of October, is 14 days notice for rent arrears of 2 months as pre-COVID, or is the rent arrears now doubled to requiring serious rent arrears of 4 months? So essentially, after the 1st of October, things will revert to the pre-pandemic situation. So I think, as I said before, it's 2 weeks notice period under the 1988 Act, and I think 4 weeks notice period under the 1985 Act. In terms of the level of arrears, that will depend on how frequently arrears are payable. Rent is payable. So for instance, if rent is payable on a monthly basis, then off the top of my head, I think it's 2 months worth of rent arrears that are required. So yes, the headline is we're just returning to pre-pandemic situation.
Okay, I think the next one is for me. Mental health crisis moratorium lasting 30 days after treatment. What constitutes treatment? Is it prescribed medication, as many are on tablets for years? That's a very good question, because I think it highlights what it's not just, you can't just get a mental health crisis moratorium because you've been on tablets for years and your doctor says things that might be better for you not to have to lose your home because it will be bad for your mental health. The treatment is as certified by the approved mental health practitioner. It really is more than somebody who's on tablets for years, as you've said. I mean, you're dealing with people who are either sectioned in a place of safety or having crisis care either as an inpatient or in the community. So this isn't somebody who is attending the primary caregiver like a GP. This is someone who's been referred on for crisis care. So it will be up to the approved mental health practitioner to say how long the treatment is going to last and when it is finished. So that's that. Next one. I'm just taking these in the order that they came in. If my thing will play well. How does the standard breathing space work in relation to debt relief or other insolvency action? The big, you can't have both. The big difference, and I think the breathing space is going to become more relevant to landlord and tenant actions than debt relief orders has been up until now, is because there was that case, wasn't it, about 10 years ago, People for Places, I think it was, which confirmed that a debt relief order, while it will prevent the landlord from taking action to enforce a rent arrears debt, it will not stop possession proceedings. That is in contrast to the standard breathing space moratorium, which does. So that's why I think you're going to see a lot more of these than you have in the past of debt relief or other insolvency type actions. But if a debt relief order is in place, my understanding is that will prevent a standard breathing space moratorium from being entered into. But again, that might be something that you'd have to get into in terms of the regulations. So under the mental health breathing space, debtors' ongoing liabilities are not required to be met by the debtor. They don't stop accruing, but you can't enforce them until the moratorium is over. Okay, Charmaine, I think this is for you. What happens if you use the old Section 8 notice after the 1st of October 2021 instead of the new one?
Yeah, that's a good question. So ultimately, I think as the whole purpose of the updated Section 8 notice is to reflect the current procedure, and after 1st of October, that procedure pretty much shifts back to the pre-COVID situation, that regime will be less favourable to tenants than it is now. So after 1st of October, there'll be shorter notice periods, for example. So more favourable for landlords and less favourable for tenants. So I don't think it's the end of the world necessarily if you use the current Section 8 notice after the 1st of October, as long as the substance of the Section 8 notice is all really clear. So for example, you state the grounds relied upon and the level of arrears and etc. However, obviously, I think it would be better to just use the correct Section 8 notice off the bat, just so you don't encounter any difficulties later on.
And we've got two people looking for the citation of the Pease and Carter case that you referred us to earlier.
Yes, of course. So I'll read it out now, but I'll also type it in. So it's Pease and Carter 2020 EWCA Civ 175. And I also have the citation for Manai Investment and Eagle Star Life Assurance, which is 1997 AC 749. But I'll just type those into the Q&A now, just so everybody's got that. If you just bear with me a moment. And perhaps Niamh can take another question in the meantime.
Okay, my client is a private landlord with a tenant who has refused to pay rent for over 2 years. He cannot locate the tenancy agreement. Is this likely to create an issue? How could he overcome this? Well, I probably need a bit more detail. I mean, no, it's not going to stop you from getting possession. It depends on how long they've been in there. I mean, have they been in there since 1975? In which case, it might be rent tax. I need to know a bit more of the background before I answer that question. The answer is he will. The fact that you can't get the tenancy agreement is not going to prevent you in due course in getting a possession order. Chris Byrne says, for what it's worth, the case of Tari Holding the McDonald usually pressed into service for the contention that a failure to file a cost schedule wasn't an absolute bar to make the making of a cost order. Thank you. Yeah, that's it. You will be in the hands of the court, though, let's face it. I mean, either a judge is going to go, right, yeah, you can have your costs, I'm happy with that, or they're going to say, no, you haven't filed your cost schedule, will go away. So we've got, please, and somebody's looking for Section 21 proceedings. I don't think we can deal with that today, and I've got my eye on the clock. I do know, though, that we're either due to have or have had a webinar at 42 Bedford Row about Section 21 proceedings after the 1st of October. Have a look on our website. If it's not there already, then it's coming up, and you should have a look at the upcoming event section. Okay, that has taken us very nicely to 6 o'clock. So I'm going to say a goodbye to everyone. Thank you so much for attending. So what was CPR reference for ticket cost and rent arrears possession? It's 45, isn't it, Charmaine? CPR 45 deals with
yes,
fixed costs
and for
fixed costs generally. Yeah,
and for the meaning of undefended, if you just look at 45.12, but yes, it is 45.
Okay. Thank you everyone for attending, and yes, please do keep an eye on our website for our upcoming housing and landlord and tenant events, and have a great evening. Goodbye.